After having my BCS case dismissed, during my case, they ended up having connection with my oldest daughter's biological dad. He lives out of state. When we ended our relationship, it was due to domestic violence, and he ended up just leaving the state, and I've had my daughter for the past 5 years all by myself, no help whatsoever, no birthday cards, anything like that. So I'm preparing to file for custody. That way there's a court order in place, so I can make sure she's protected if he were ever to just pop back up. I am all for having my daughter have a relationship with her biological dad. However, due to the
Heather.
Yes, hi, I'm still here.
Okay. Heather, you had a question you wanted to ask me. Go for it.
Yes, so I do have a quick question. After having my BCS case dismissed, during my case, they ended up having connection with my oldest daughter's biological dad. He lives out of state. When we ended our relationship, it was due to domestic violence, and he ended up just leaving the state, and I've had my daughter for the past 5 years all by myself, no help whatsoever, no birthday cards, anything like that. So I'm preparing to file for custody. That way there's a court order in place, so I can make sure she's protected if he were ever to just pop back up. I am all for having my daughter have a relationship with her biological dad. However, due to the severe domestic violence, felony strangulation charges, all of that, I definitely want to make sure that a psych evaluation is completed. It may have been 5 years, but I feel like that's necessary before any reintroduction occurs. That being said, and the fact I'm filing this all by myself, I do have a question. So I was able to come across the Resolution 72 from Congress, and it expresses the sense of Congress that child safety is the first priority of custody. And so my question with that is, how and would somebody want to put that in their filing? The way that I summed it up in what I have prepared to file is that I'm requesting the court order for Party B to obtain a psychological evaluation to show mental fitness before reintroduction occurs, supported by, and then I put that in there. I don't want to offend the judge by any means. I don't know exactly how to handle that to bring it to their attention, as this is something that backs up what I'm requesting before reintroduction occurs. So I just didn't know if you have any advice you can give on that, or how you would handle a situation as such.
Sure. Well, I'm going to answer the question, but first I want to give you a pre-warning. I'm licensed in California, not Arizona. So I'm going to answer the question as if it were in California. First of all, that federal law that you cited, generally federal laws like that don't have to do with state custody and visitation issues. And now we're not talking about a CPS case. We're talking about a family law case when we want to issue just regular custody and visitation orders. Having said that, there's probably a plethora of authority and case law in your state that permits you to ask for that type of order. But here's the first thing. In California, when you exit a juvenile dependency case or a CPS case, the court usually, and I even think there's a statute on this, usually orders a family law custody order out of the juvenile court, and then it's filed in both the juvenile case and the family law case. So if they don't have that in Arizona, the reason why I mention it is because you might already have a custody and visitation order for that child. But if you don't, you can make a motion to establish that. And that's actually a good idea. I'm not sure that it's, quote unquote necessary, because you said the guy hasn't been around for 5 years. So you should go ahead and file that request for the evaluation. And, probably if it goes unopposed, the judge might grant it, or probably would grant it in California. And while you're at it, what I would do is I would tell you in California to make that motion for child support at the same time. Because child support, interestingly enough, Heather, doesn't belong to you. It belongs to your child, right? At least in California. So, the money that you're saying, oh, I don't need, well, maybe the kid needs it. Maybe the kid wants to buy a new laptop computer, wants to pay for some, special activity, outside of what, what you normally do or are able to afford to do. Or you can just put it in the bank and the child could use it later for college or, something of that nature. So if you were in California, that's what I'd tell you to do. All right?
All right. Thank you so much. I appreciate that.
Surely. Let's take our next call. Leticia from California. Leticia, did you have a story to tell or a question to ask?
A story to tell and a question to ask. My name is Leticia. I'm from San Diego, California, and I'm a grandparent of a 1-year-old child. Her name is Purpose Fields, and pretty much I want to find out more information and find out about helping get her before she is adopted out if she isn't already. Okay. Originally, the case happened with my daughter. My daughter's 26. Her and the baby was born with substance in their system. And so CPS got involved and wanted to take the child. And I was willing to get the child as long as they said that my daughter would have to be in agreement. And they told me that I had to go through this paperwork. And I'm her, maternal grandmother. And I didn't want any services or anything from CPS. I don't have a CPS case. I did have a case many years ago with my granddaughter's mother. That case was closed. I did everything, therapy and all this good stuff with the kids because my daughter, was running away and saying things that wasn't true. And, it's about protecting the child first. I do understand that to make sure that things that the child is saying is not happening. And so everything they had asked me to do, I did. Even though I was humiliated because the things that was being said wasn't true and they didn't find it true. The case got closed. Okay, so I told them about that. And then she told me I would never be able to get my grandchild. And I'm like, wow.
Leticia, I'm going to tell you exactly what you need to do. I hope you have a pen and a piece of paper.
Okay.
Number one, you need to file what's called a 388 petition to have the child placed with you. That's filed with the court clerk and the judge. Number two, you should probably file a motion, a de facto motion, under In re Charles S. to try to get standing in the case. Number three, you should file a petition to have the records disclosed to you so you can see what they're saying about you. All right. And number four, sometimes what I do, although people don't agree with me, I file a petition for legal guardianship, both permanent and temporary. And the other thing that I can do, depending on the facts and circumstances of the case, I might file for you a petition for what they call presumed parent status. That basically gives you the same rights as a parent. Now, this can only be filed generally if you took care of the child and acted as a parent before the juvenile case, began. So in California, a child is allowed to have more than two biological or two parents. And, a lot of times, sometimes it's the presumed parent, and that might be you in any case that has come before the juvenile court. All right. Now, here's the thing. how do you do all those things? That's another, that's a whole nother topic we could spend hours on. If you want me to give you some more information, I want you to give me a call at my office, 888-888-6582. Call tomorrow or Monday, because depending on where your case is or where the case is in the system, you might want to move or you might have to move very quickly. Okay, I want to thank you for calling and thank you for listening. Call back in 3 or 4 weeks. Let the audience know what's going on. We have to take another break right now. This is The Secret, How to Fight CPS and Win. We'll be right back after these messages.